you guys have handled thousands of, and even spoken to thousands of claimants that have been denied long-term disability benefits by Lincoln Financial. And when people get these denial letters, they don't know what their options are, what to do. More often than not, unfortunately, they get a phone call from someone at Lincoln Financial and says, our doctors have found you're not disabled, but don't worry, you can just go ahead and send us some more information, or put together something and we'll review it again for you. And claimants don't understand the magnitude of what's involved by doing something quick. And they also don't understand what their remedies are, because at first they're mad and they're like, I want to sue you. I just want to sue you and get my money because you've done wrong by me. But these claims are governed by ERISA, as you know, and they have to file an appeal. So I want to talk a little bit about the things that you do to help people win their Lincoln Financial ERISA disability appeals. And Alex, I'll start with you with the first steps of what you need to do once someone has provided you with the Lincoln Financial denial letter.
So I hear that more and more from claimants. When they call me, they go, oh, I go, did you file an appeal already? They go, yes, I told them I wanted to file an appeal. And I always go, why did you do that so quickly? Have you received the denial letter? And half the time they said, no, I haven't even received it yet. I go, well, why did you already file an appeal? Well, they told me if I want to get back on claim, I need to file an appeal, and I can do so. I just tell them to file an appeal, and they'll start the appeal process, send it to the appeal people. And it's a trap. It's 100% a trap. It's immoral that some of these claim handlers are doing it, because I think what they're trying to do is keep their numbers high, like their denial rates high, and even on appeals, they don't lose their appeals. I don't know why, but if they're doing it on purpose, it's simply immoral. But when you get a denial letter, the first thing you should do, besides calling our firm, or the first thing I do, after I speak with a now client and now I'm representing them, is get a copy of the claim file. The insurance company under ERISA has to provide you a copy of the claim file, and that's basically every single piece of documentation that they've compiled on your case, whether they ordered the records from your treating providers, whether they had one of those independent physician consultant reviews done, or in-house reviews done, anything that you or your providers have submitted to them, it's all in this claim file. They have to give it to you. So everything that they're hanging their hat on to deny your claim, it has to be provided to you. And the first thing I do is I get a copy of that claim file and I tear through it. I want to find those consultant reports, because if my client is telling me they're disabled, I have to figure out what's going on in those consultant reports, what holes are in those consultant reports, because I'm going to take my client's updated medical records, updated treatment that we send them to, updated testing we send them to, and I'm going to plug holes in those consultant reports. I'm going to fill those holes with our proof. But the most important thing is getting a copy of the claim file, getting updated medical records, updated testing that we can send our clients to, and then we review everything and finally put together an appeal. But it's a timely process. You can't just rush a quick appeal out.
And Cesar, when you're working on appeals, often claimants are like, well, my doctor submitted the information. What more can you do for me? Why are you seeing this differently than what I'm seeing? So talk about how, based upon your experience of not only having seen thousands of these denials, but also thinking about if Lincoln Financial were to deny this claim, how's a judge going to look at this, right? Sure. But more importantly, really talking here about the facts of how you're able to build a strong case in a better way than a claimant could ever do for themselves.
So hitting on the point that you mentioned, where someone's doctor may have submitted some additional record or a letter. I've seen that many times. Oh, I told Lincoln that I'm appealing the decision and I provided a letter from my doctor. The problem with that is that I'm not to devalue what who your doctor is or what they do for you, is that oftentimes whatever's being submitted either by you or your doctor isn't really addressing the issues that the insurance company is really denying the claim on, and the evidence that they're using, or lack thereof, to deny the claim on. And if you aren't really surgical with how you're hitting all of these points that the insurance company is using, or Lincoln in this case is using, to deny your claim, you're going to be in real trouble, particularly in that litigation stage you're talking about, where it may end up in front of a federal judge one day. Because, a federal judge isn't looking at, well, did the doctor submit this additional letter explaining this or that? They're looking for other pieces of evidence. I mean, I know that we had a case not long ago where the judge was really focused in on functional capacity exam and testing, and how this is the gold standard in terms of establishing the evidence necessary to show that someone has particular physical limitations, functional limitations. Okay, So if your doctor's just written a letter and some additional evidence hasn't been submitted or used to address a lot of those points that Lincoln's gone through to deny your claim, then you're going to be in real trouble at those later stages potentially. And not to mention, your claim's not going to get overturned.
Yeah, I think what has to happen is you have to know how to put in every single piece of evidence that could possibly show that you're unable to perform either the duties of your occupation, or if the definition of disability happens to be any gainful occupation. And one of the beautiful things I like, because a lot of people badmouth ERISA and how it's not fair and all these other things, but let's talk about the positive of ERISA. In this ERISA appeal, you could literally put in every single piece of information that you want. Lincoln has to consider it. So, being ridiculous, I could send them 1,000,000 pages of information, and if they don't review all of that information, it could be considered that they performed an unreasonable review of the file. So I'm not saying you send them a lot of nonsense, but you have the opportunity to send them everything and anything related to your medical condition, why you can't do your job, things defining what your occupation is, and we can almost guarantee that they're just not going to review everything. Maybe going to miss something, but you need to plant those seeds so that you have it for later, which is what we talk about in our lawsuit videos and how we handle lawsuits against Lincoln Financial. So you need to have that in the back of your mind. And I know I always talk about, and we always say that when we start with these appeals, it's like starting with a blank canvas and we're painting this picture. The tools that we have, the colors that we have to paint this canvas is what's in that claim file that Alex describes, but that's not enough. So it'd be like giving us 3 colors of paint and going, go ahead and paint. And be like, no, this needs to be 10 colors. And that's where we come in as the lawyers and say, this is all the things that have to be done. And before we even write that appeal, I often tell the clients that 80% of the victory of this, or how I think we're going to win, is done, because it all comes in getting that additional information. And then we go ahead and put the pen to paper to write what's a super strong appeal. But the one thing we didn't say, Alex, that I just want you to comment on as the last thing for talking about appeals and how we help people is, why is it so important to get every single thing in? But keep in mind that some of the Lincoln policies allow for two appeals, which is a rarity.
Correct. So some policies do allow 2 appeals, so sometimes you might get a second bite of the apple to strengthen your claim file. And the reason why earlier I said it's a trap to do a quick appeal, because they know if they do a denial, the day of their final denial where they say, no, we're denying your appeal, whatever date that is, the claim file closes. And that's something unique to ERISA as well. And while that's very important to note, is because once the claim file closes, no other information can ever get in that claim file. And that claim file is what's going to go in front of the judge. The judge is going to ultimately render a decision on the case, and basically he's going to listen to the arguments of the attorneys, or she's going to listen to the arguments of the attorneys and review the evidence inside the claim file. So once that claim file closes, if there's an FCE that you went and did on your own, if there's there's another doctor you never sent that doctor's records in, it's not in that claim file, that the judge is never seeing it. So it's so important. I mean, your appeal is so important for 2 reasons. It gives you 1 chance, or sometimes 2 chances, to get back on claim, overturn the denial, and get back on claim, start receiving benefits again. And the other important reason to do the appeal properly, because it builds your case for the potential lawsuit. It's your last chance to provide all that evidence and paint that picture for your lawsuit. And once that claim file closes, again, that claim file is closed forever. I mean, there might be some very unique circumstances where you get more information in, but I would not rely upon that. So every single piece of supportive medical record has to be in with your appeal. So that's why it's a trap. If you do a quick appeal and submit nothing else, you're going to lose your appeal, and you're probably going to lose your lawsuit.
I was going to finish with Alex, but I have one question for you, Caesar. Why do you think that Lincoln Financial is one of the companies that in many of their policies require 2 appeals as opposed to 1? Why do you think they want that? And they're one of the few companies who do that.
I mean, look, I guess it's a matter of looking at things somewhat cynically, because I think that while, look, there's no question the appeal process is extremely important. Alex touched on all those reasons. But I think the longer that because Lincoln can hold out forever, you know? I mean, they're holding the money, right? But the claimant can't. So an appeal could take up to 180 days, right? And not to mention the period of time that claimant has now gone without those benefits before that appeal period started. then the insurance company could have up to 90 days. Lincoln could have up to 90 days to decide that first appeal. And then they may even extend that because they say, well, we're waiting this piece of information, or we're going to toll it for this reason or that. So maybe it goes a little beyond that. Then they ultimately deny that first appeal. Then they say you have another appeal that you have to pursue. Maybe somebody gives up at that point.
Do you get another 180 days on that second?
You get another 180 days on that second appeal.
Wow.
Okay. So, but maybe that person gives up and says, oh, well, you know what? I'm not even going to try now because, you know, they've overwhelmed me, and they stop. Okay. Lincoln's won. 180 days in that second appeal, another 90 days, potentially longer than that. I mean, we're talking about potentially years before that person even has the potential to bring their case to the federal court. So it's just a matter of, you know, waiting and waiting, and these people going without money and benefits that they so much need. And some people, they, like I said, give up, return to work, or something else happens where Lincoln just no longer has that level of liability and exposure anymore.
So you think their strategy was to push people away, because if we deny them initially, that's number one denial. We deny their first appeal, that's number two denial. So you think a lot of people just drop off and go, we're not going to fight this anymore. And then if they deny them again, that's a third denial. So they get 3 bites of the apple to review. I think, yes, they try to bleed them. My other thought process is that they then get to argue to the court to say, Judge, we looked at this 3 times. We gave them 3 potentially independent reviews. How could you say we didn't act reasonably? And I think that for them, they see it as a double win. We're going to delay like you did, which was spot on. And number 2, they're going to say, well, of course we did a reasonable review. We had 3 different doctors. We had 3 different vocational people. We did all of these different things. And I think that's their basis for doing that.
And to be clear, actually, ERISA allows an insurer to mandate or require 2 levels of appeal if necessary. So
right, so it's not a made-up thing that they're doing. Right. The laws were, and you know, the laws were set like that because the whole basis, how Alex was saying everything about ERISA is horrible. It was set up like that because the point of ERISA was to make it so that you avoid litigation. So when they crafted the laws back in the 1970s, the point was, let's make them do 2 appeals so that, you know, on the one hand, they're going, well, the claimants are going to get 2 independent opportunities to have their claim review. But at the same time, the cost of litigation isn't going to be there because it's that much longer until it gets to litigation and the company's doing the review. So it's keeping the cost down for the company, giving them 2 chances to try to review the file. So that part I don't believe works in the favor of the claimant. But what you want to do with Lincoln is try to win the first appeal, obviously. And if you don't, people call us on the second appeal, and you still can do great things because you have that opportunity to do that. So it could be a bonus for someone who tried to do it on their own the first time, which I don't recommend, and gets a second bite of the apple.
But don't forget, it's not always Lincoln. Not all policies of Lincoln require a second appeal or allow a second appeal. So keep that in mind.
And the other issue also is for someone has to be very aware of what their statute of limitations is, because usually statute of limitations do toll during voluntary appeals, but not during mandatory appeals. So while all this time is going by, you know, at the end of it all, they may only have a few months or a very limited time period to file a lawsuit.
That's a great point. So if you're someone out there who has a Lincoln Financial disability denial, feel free to reach out to Alex, Caesar, or myself. No matter where you live in the country, we're available to assist you, and we'll always provide you with a free consultation.